dear fellow panelists, ladies and gentlemen. At the outset itself, let me thank the organizers for giving me this opportunity to express my views on this issue, which is very pressing at this moment. The fellow panelists have raised various pertinent points on the tribunal, the People's Tribunal, the so-called People's Tribunal, including the politics behind it. I would not attempt it again. However, I would like to look into this issue in a different angle. As we know, Uyghur Tribunal is not the first of its kind as a non-state initiated tribunal. The world has already seen people's tribunals like the China Tribunal, the Kuala Lumpur War Crimes Commission, etc. So even though these so-called people's tribunals claim to be judicial institutions using universal jurisdiction, hoping to be an alternative to the institutions like the International Criminal Law and, of course, International Court of Justice for that matter, in reality, they just remains as a tool of advocacy and activism for pressure groups. We can approach these courts in two ways. The first approach is by denying them in total as an advocacy effort and shove them aside, saying that they are just kangaroo courts. Or second way of looking at it is to analyze their structure and approach in a legal way. I think the second way is imminent at this point of time because of the continuous popping up of tribunals like this. So we need to see, of course, these are non-state entities, non-state companies, just like Mr. Lehman was mentioning. It's a non-profit company registered, and they don't have a legal background to constitute a criminal tribunal like this. So it will be really interesting to look into the aspects of the legal aspects, the legal veracity of these kind of organizations. So that is what I'm going to talk in the next 10 or so minutes. Very quickly. As a judicial institution, as they claim to be, they don't have any backing from any state, and their relevance and importance will remain only if they form and follow the norms of judicial institutions elsewhere or at international level. The judicial institutions are relevant only if they follow an established law and procedure. As far as this Uyghur Tribunal of any of this kind of people's code, the law and procedures they use are normally the established international laws and procedures which are available and accepted by majority of the countries in the world. But the way it is being implemented through these codes are questionable. That we all know, the quality of evidence collected, the way the witnesses are being influenced, the biased notions of the judges, etc., all comes under this aspect of using law and procedure accepted by international bodies. Then the qualification and capability of the officers of the court to carry out the functions of the institution is also very important and is very questionable in many of these institutions, in many of these courts, so-called courts. Even though some of the judges and prosecutors are qualified legal practitioners, just like we were talking about Mr. Nice, but most of them are not. And many of them are drawn only because they are associated with the cause for which they are implemented. That we will see as we go ahead discussing further aspects of this analysis. This all diminishes its legal value as a code. Then comes the jurisdiction part, and we all definitely agree that they don't have any jurisdiction to entertain an issue like this. Just to analyze it further, international criminal jurisdiction falls on a subject matter normally on three circumstances. There could be other circumstances also, generally on three circumstances. One, when the consent of the states through signature and ratification is accurate, which is mostly done by international organizations and international courts. The second one would be the compulsory jurisdiction accorded by an international organization based on a previous treaty obligation, just like ICTY and ICTR got its legal sanctity, just like what has been explained in the Tarish case. The Security Council initiated the establishment of this court, and there's a compulsory jurisdiction on that particular subject matter. And finally, the universal jurisdiction. As we know, the first two don't even exist for these kind of institutions. But now coming to the universal jurisdiction, the answer is negative again. The main reason being such privileges are only given to sovereign states. There is no indication under international law, treaties, practice, or customs which entitles a non-state party to exercise universal jurisdiction. And last but not the least, if you look at another important aspect, perhaps the most important aspect of these tribunals, or the test for these tribunals, are lacking of natural justice principles of independence, impartiality, and neutrality in legal adjudication, which is totally not found in these kind of constituted courts, people's courts. No need to mention that independence, impartiality, and neutrality are values which are imposed a duty on adjudicators to be independent, impartial, and neutral, at least as far as this is possible. When we talk about independence, impartiality, and neutrality, we are referring to values, legal principles, institutional conditions, genuine duties held by institutions in first place, and secondly, coming to the second level of independence, impartiality, and neutrality, that is that of adjudicators' own personal nature and their states of mind, which includes their beliefs, desires, their alignment towards a cause, etc. All comes under this. So let's have a look quickly at these three important aspects and how they reflect upon organizations like this. Independence, under the influence of positive law, is usually associated with certain institutional guarantees or safeguards that allows adjudicators to free themselves to some extent from external pressure when making their decisions. Such safeguards include, among other things, neutrality of appointment of procedure, the stability of the position, autonomy of the organization, the legal basis of the organization, etc., a reasonable sphere of immunity and inviolability to the judges, etc. If we look at the case of these kind of people courts, external pressure could be immense. It could be from governments, because the speakers before me has talked about how few other countries have influenced the Uyghur tribunal. So that pressure could be immense. After constituting a tribunal for a cause like this and subsequently deviating from a predetermined judgment is impossible, because you have a huge pressure from the governments who have funded you, who have promoted you in this particular issue. Then public opinion is a big thing where you are situated. Media demands are overwhelming in most of the cases. Then appointment of judges and other officers of the so-called courts are influenced by advocacy interests, for sure, because most of the people who are associated with such courts are none other than the people who work for this advocacy. So the fairness, the independence of their thought process is very much questionable. Then further, the judges' autonomy, that is also influenced because of the same elements, even if that person is from a different context altogether, because of the pressure which could come from other sources when he is sitting as a judge would be overwhelming and cannot be retracted. Then coming to the impartiality, in contrast, is usually associated with the objectivity of decision or absence of prejudice towards one or other of the parties. There is also distinction to be made between personal impartiality, which depends on having no stake in the outcome of the proceedings, with the adjudicator simply being one more actor in the conflict that is being resolved, and the institutional impartiality, which is rather more related to what is usually referred to as an independence. So what here we are talking about is the impartiality of the individuals who are involved and the impartiality of the institution as a whole. And we can assume very well that in tribunals like this, both personal impartiality and institutional impartiality are compromised, as the constitution of these kinds of courts are part of advocacy strategies and interests. Last but not the least, the neutrality is normally something which is go in tandem with independence and impartiality. But neutrality may also refer to absence of some kind of nearness, and the judge may have that nearness or affinity or proximity without it necessarily compromising his or her impartiality. So even if, as I was mentioning in the impartiality part of our discussion, even if the judge is from another realm who has nothing to do with the cause which he is judging, his nearness and his proximity to the people who wanted this to be done definitely influences neutrality. So I think all these three are negatively impacting upon the constitution of courts and tribunals like this. The analysis in total shows that the notion of independence, impartiality, and neutrality are elusive in the case of these kind of courts, and the general understanding of illegality of such institutions need to be reinforced. I will stop it there, and I'm happy to come back and answer to any queries that may have in the subsequent discussion part. Thank you so much.